Welcome to Your Inheritance, your rights, your obligations, your responsibilities, with your host, Peter Bochnewich. In each episode, you'll learn insights from experts. If you're being sued over an estate or if you feel you're not getting your share, Peter's firm can help you. You can find this show at www.betrustlaw.com and on YouTube, Facebook, Apple Podcasts, Spotify, Google Podcasts, and more. Now here's the host of Your Inheritance, Peter Bochnewich.
Good morning and happy St. Patrick's Day. I'm wearing green on my tie for St. Patrick's Day. It's March 17th, 2023 for this podcast episode. And today we are going to just be talking, me to you, about what is a last will and testament and should you have one. And the short answer is yes, everybody should have a last will and testament. Now, in these podcasts, we always cover a broad range of topics with respect to wills and trusts and things related to the estate planning arena, and including in some of our podcasts, litigation in that area, which is where the focus of my law practice is. But today we're just going to be talking about something simple but very important, the historical underpinnings of what we know to be a last will and testament. Now, the podcast platform folks want me to tell you this, and I need to tell you this. Nothing in this podcast is legal advice. If you need legal advice, you should seek out your own lawyer, give us a call, and we try to help you. But this is hopefully to be informative to you, our viewers, and I appreciate your being here. So, what is a will? It's very interesting. When you look back in the history of wills, it really is a derivation of will, as in willpower, as in expression of will, as an expression of what you want to do with your property. And a will is basically, looking at it as a legal definition, right from the dictionaries on legal terms. It's a legal expression or declaration of a person's mind or wishes as to the disposition of his property, his or her property, to be performed or to take effect after that person's death. So basically, your will, what you want to do, how you express your wishes, is memorialized in a writing, and that writing tells the people who follow you, your designated person, which in California and most states was called an executor, who executes the will, executes your wishes to carry out who gets what of your property when you pass away, according to the specifics set forth in the document that you leave behind. So it's really quite simple to understand what all the rules are, because the California Probate Code lays them out in the state of California very, very much great detail. Wills and intestate succession are in the California Probate Code, beginning at Division 6 and starting with Chapter 6100. And that chapter talks about persons who may make a will. Who can make a will? A person who can make a will under 6100A is any individual 18 or more years of age who is of sound mind and body to make a will. That's something that you probably always hear all the time about. I am of sound mind and body. Of course, a person's got to be of sound mind and body to express their wishes about what they want to do with their assets. In the case of a person who's in a conservatorship, a conservator may, under appropriate circumstances, make a will for a conservatee if there's a court order allowing that. But a conservatorship by itself does not take away the person's right to make a will, a simple will. There are different rules with respect to trusts, and we'll cover that in another podcast. But basically, any person who's 18 years of age or older who has capacity can make a will. So what do you need to do to make a will? Does it have to be complicated? Is it an expensive task? Well, it doesn't have to be. A will can be holographic if you want it to be. I don't recommend it. I think that if a person has any substantial amount of assets, of course, they should have a more elaborate estate plan. But at the very basic roots of what you're able to do, you can write out in your own handwriting what's known as a holographic will. And California has a specific rule about how you do that. That's probate code 6111 6111. And let's see what that says in terms of making a holographic will. So if a will is not in writing, and we'll get to that in a minute, witnessed by two people, you can still make one if it's holographic. Holographic meaning that it's in handwritten. It's an expression of yourself in your handwriting, And under 61111A, a will does not comply with section 6110, formal will, is valid as a holographic will, whether or not witnessed, doesn't have to be witnessed, if the signature and the material provisions are in the handwriting of the testator, the person who is making the will. I had a circumstance in a case once, as a matter of public record, I won't give any names or anything like that, but a gentleman who was committed to making a specific gift to someone he cherished very much, found himself near the end of his life, was literally having a heart problem, and he apparently reached for the cardboard cover to a hanger from the cleaners that came in a particular hotel room he was staying in, and wrote out on that cardboard an express instruction to his daughter, who was to be his executor, and said, make sure that person that he designated gets X amount of dollars out of my estate, identified the person, signed it, had it dated, and we were able to admit that as a holographic codicil to his pre-existing will. And there was some debate about its authenticity and so forth, and there was a little bit of a dispute, but we were able to resolve that litigation for most of what was put down in that holographic instrument. It was written out in the gentleman's handwriting. He was of sound mind and body when he was writing it. He was just having a physical problem. And after that, unfortunately, the man did go to the hospital and he did pass away. But he expressed his wishes in a critical moment of his life. He expressed his wishes. He wrote it out, signed it, and dated it. And it was a heartfelt expression. It was backed up by other documents. And that was determined to be, and ultimately we settled that case. That was settled as a holographic codicil to a will. And also I pled it as a holographic amendment to the trust that he had, when we'll discuss trusts at another time. But that's how you can do a will. And it's not something that would ordinarily be the topic of advice or the subject of advice for most estate planners. I don't recommend it. You should have a formal will. It should be witnessed by two people. But in a pinch, that could suffice. Law in the state of California does not make it super complicated for you to accomplish your estate planning. There is even online, you could access, if you wish, a statutory will that is basically a formal will that is a fill in the blanks, and you could just go through it and it will ask you questions and you will give answers. And that is a form of will that might accomplish some estate planning objectives, or most estate planning objectives, if that's the way you want to go. And you don't have time to get to a lawyer or anything along those lines. So that's available if you simply go online and Google it, or do a search with whatever search engine you use, and you search the term statutory will. Probably best, if you're going in that direction, to go to an official California website that holds it. I do believe the State Bar website might have one, but the California website, the government website, does have a statutory form will. And those, if filled out properly, can be very effective. And they're just like a will that you would get done in a lawyer's office, but perhaps not with all the intricacies. If you have a larger estate, you really want to see a lawyer for your estate planning needs. So that's the basic concept of a will. There is a necessity of writing. If it's not written in your own handwriting and not a holographic will, then under probate code section 6110, a will shall be in writing and shall be signed by the testator, the person who is making the will. That's the primary. Obviously, it has to be signed by the person who's making it. And except with certain exceptions, the will shall be witnessed by two persons, signed, obviously during the testator's lifetime, by at least two persons who are present at the same time and witnessed either the signing of the will or a lesser circumstance that happens, the testator's acknowledgement of the signature of the will. And that's a statutory requirement. So what you have to have for a will, if it's a formal will, if it's typed, it needs two witnesses to be a valid will. Now, sometimes the formalities of a will are, for whatever reason, not met. And if that's the case, there is some relief available under the statutory scheme in the state of California, and that's also embraced by California Probate Code section 6110. And at that section, it says, section 6110, reading directly from the statute, that's subsection C2, that if a will was not executed in compliance with paragraph 1, the will shall be treated as if it was executed in compliance with that paragraph. If the proponent of the will, the person bringing it to the court, say, yeah, this is not quite right, you didn't do everything right, or she didn't do everything right, mom, dad, grandma, or grandpa, but we've got proof that that's what they intended. Most of the elements of a formal will are there. They may have missed on some of them. Maybe only had one witness or whatnot. But if it's not executed in complete compliance with the formal requirements embodied by the statute, it could be proven as the last will and testament if the proponent establishes by clear and convincing evidence that at the time the testator, person who passed away, at the time that person signed the will, the testator intended that will to be his last will and testament, or to be her last will and testament. So you need clear and convincing evidence. If it's not self-proving or it's not got all the elements of the formal document as the statute otherwise requires, you can prove it up if you come to court and you're able to prove by clear and convincing evidence that it is the expression, the written expression of the testator's intent. Clear and convincing evidence is a high burden of proof. In the law, we have various burdens of proof. You've heard of a preponderance of the evidence. Again, this is not legal advice, but it is just a general discussion on the burdens of proof. Preponderance of evidence is typically discussed this way. If you've got 51% of the evidence and another viewpoint or another party has 49%, that's a preponderance. It tips the scale over in favor of the party who has the preponderance. More evidence in favor than not in the eyes of the trier of fact who is reviewing it. A lot of people most cases are tried, a lot of cases are tried in folks' common knowledge before a jury. In probate court, the trier of fact is the judge, the probate judge. In probate court, there's no right to a jury trial over anything except under limited circumstances. For example, in conservatorships, a proposed conservatee who's going to have a conservatorship imposed over them, they may request a jury trial. Other than that, there's specific statutory language in the statutory scheme that anything covered under the probate code, there is not a right to a jury trial. It is a judge trial. The judge sits as the trier of fact. They receive the evidence and the singular judge makes the decision over matters of probate and will contests and disputes over inheritances and disputes over trusts, trust litigation and things of that nature. Sometimes there are cases that blend both civil and civil matters and probate claims, and that would be discussed at another time. But if you can prove to a judge that a will that was not quite done up to snuff according to the statutory scheme, and you have clear and convincing evidence, which my recollection of the case law is the unhesitating assent of every reasonable mind, that it's really clear to the judge that no one could really dispute it, that's a high burden, then you can get your will admitted to probate. And in that case, there are specific statutory guidelines for the admission of what's called extrinsic evidence. You have the will document, but if you need something to show that that was really the intent of that person because it doesn't fit on the all fours, the technical statutory requirements, you could look to the code section of 6111.5 as to the admission of extrinsic evidence. And that code section says, extrinsic evidence is admissible to determine whether a document constitutes a will pursuant to section 6110 or 6111, or to determine the meaning of a will or a portion of a will if the meaning is unclear. So if there's some ambiguity in the document, extrinsic evidence, maybe there's other letters that the testator wrote about the will that can be authenticated, or any other sorts of evidence that could be used to authenticate the will. I had a case once where someone wrote out a holographic instrument that came very close to the decedent's death, and they had left a corresponding message about what they wanted to do that kind of dovetailed with everything that was in that document on a voice machine message, and that extrinsic evidence helped confirm the intent of the testator and confirm the document that arguably had some imperfections in it as, in fact, the last will and testament of the testator. Who can be a witness to a will? Well, any person generally competent, in their, they don't have any significant mental problems that are going to keep them from understanding what they're doing. Those persons can be a witness to the will. And Probate Code 6112 states that at subpart A, any person generally competent to be a witness may act as a witness to a will. So it could be anyone. Subpart B says that a will or any provision thereof is not invalid because the will is signed by an interested witness, although best practices might be that you have disinterested persons. If you go to a law office, they're probably going to have folks in the office that are going to talk with the person who's making the will. They're going to ascertain that that is their last will and testament. They are going to have a statement in the body of the will that they have had that expression from the testator that this person said at the signing that, yes, this is my last will and testament. This is what I want done. And that person was at the time of the signing to the apparent perception of the witnesses, free from undue influence, and that they appeared to be, as they said they were, of sound mind and body to go ahead and execute the will. Okay, so a will is valid. A written will under Probate Code 6113. A written will is validly executed if its execution complies with any of the following. If you do everything that you're supposed to do in 6110, or if you're not doing it according to that, you have a valid holographic will. There is, when we get into the creation of trusts, which is a trust is a legal document. It's similar. It's a testamentary instrument, and it works hand in glove with wills to carry out the wishes of the person who is making the trust, the settlor of the trust, the person who is settling the affairs of their trust, called a settlor. And sometimes we call them the trustor. They're making the trust. And that is a different type of instrument that gives the rights to hold property in the name of a designated trustee. Typically during your life, when we call it an inter vivos trust, which would be probably heard the term revocable inter vivos trust. It's made during your life. It's completely revocable during your life. You could change it just like you could change your will. And that trust allows a successor trustee to take over your estate if they deal with proper steps of acceptance of the role of trustee and proper steps to memorialize the passing of the former trustee and trustor. And then that person, by that document and by the rights in that vehicle, can distribute the property in the trust estate outside of the supervision of the probate court. If you only have a will, then you have to submit it to probate, and the probate court will review it. The probate court will ascertain through a variety of very particularized steps that it is the last will and testament of the testator. And there is a process by which everybody within a certain degree of relationship to the testator is appropriately given notice of the probate proceedings. So everybody says, here's the last will and testament of this individual, and here's what they wanted to have done. I'm the designated executor. I'm bringing this probate petition of this will to the court to make sure that it is done as it sets forth all of the wishes that this person has and the disposition of their property. It's different than a trust, which could enable you to do it outside of probate court, although probate court supervises or has control over all trust matters, and all the trust provisions with respect to trusts are embodied in the probate code. You can distribute estates that are embodied in trust estates outside of court if it's done right. But if you have a will, you have to petition for probate. Most people would like to avoid probate. Most people would like to avoid any unnecessary trips to any court for any matter. It's not necessarily has to be an earth-shattering experience. If you do have to go through probate, the probate courts are very good. Probate courts in our area here in the Coachella Valley and elsewhere in the Southern California, I've been to most of them. The judges are diligent. The probate examiners are very well educated in their field and in their craft. They know what they're looking for, and they generally do a really good job of making sure that everybody's rights are respected, and the statutory process for administering a estate through the probate court is done right. You can't get it through if you don't do it right. So that's a little bit about the process of bringing uh, uh, the will to fruition through the probate process. Um, some of the things that folks might ask about when they're contemplating their estate planning and talking about wills and trusts and so forth are some very basic questions. And you can find these uh, at government websites as well. There are answers to questions that you can peruse free of charge, and you can and look those up. And I'll relate some of things are that are out there for you to find, and some of the common questions that might come up when you're thinking about your own estate planning. What happens if you die without a will? Well, if you die without a will, you die in what we call intestacy. And an intestate estate, if you don't have a will, then there's a statutory scheme to basically say what's going to happen. And if you die intestate, for example, if you are a married person and you die intestate, then there is a scheme that says who gets what out of your estate with respect to your community property and with respect to your separate property. And it goes by statute. We can turn and look to the statutes that talk about intestate succession. You don't want to die intestate. It's probably a good thing in your life to go see an estate planning attorney and get an estate plan that suits your needs. That's would be wise. It could help save a lot of problems for your family after the fact of your passing if you do that. It's never too late, generally speaking, to do that. A lot of people put it off towards fairly late in their lives because it's not a comfortable subject to deal with one's own demise, but it's a good idea to get something done as soon as you can. If you've got a family, if you've got children, you should have an estate plan, and you should it's a good idea to regularly update it to reflect changes in your life and changes in your family and changes in the assets that you have and what you want to include in your estate plan. If you don't do that and you died without any estate plan, the law is going to provide you one by statute, and that's in the laws of intestate succession, which commence at Probate Code Section 6400. And it's, for example, if a spouse dies without a will, one or the other, what would the share be of the surviving spouse? Well, as to community property under 6401 of the Probate Code, as to community property, if all the property that you've ever had in your marriage was community property, you don't have a prenuptial agreement, and there's nothing that says anything's a separate property, someone didn't receive an inheritance from someone else and held it as their separate property, or someone didn't hold certain package of investments as a separate property that they had before marriage, and the community, husband and wife, did nothing to affect the value of that asset, which would be pretty good description of separate property. If it's all community property, and whether dad worked or mom worked all the time, and dad stayed at home or whatever, the community worked together to get the property, and everything that you have was procured during the course of the marriage. That would be community property. As to community property, if one spouse dies without a will, the intestate share of the surviving spouse is the one half of the community property that belongs to the decedent. So you get all of it. You always have your own share of community property, but if someone dies and they don't have a will, and you get their share too. You get their share of the community property in a community property state. You also get the share of quasi-community property, which is a term that applies to if there's property held elsewhere, or if the it's not community property, but it would be treated as community property, quasi-community property. If it was held in this state, you also would get 100% of that property. So it is all of the community property, if you die intestate, would go to the surviving spouse. As to separate property, and this is if a spouse has separate property and they don't sit down and do a will and they say, I'm going to leave all of this to, maybe they leave all of this to their spouse, or they might leave it to some of their children. If they don't have a will, then the entire intestate share goes to the surviving spouse if the decedent did not leave any surviving issue, they didn't have any kids, they didn't leave a surviving parent, brother, sister, or issue of a deceased brother or sister. If that's the case, then all of the separate property, along with the community property, goes to the surviving spouse. You don't want to have to deal with that. You don't want to have to deal with that. This is why it's a good idea to have a will and a trust and an estate plan and the combination of testamentary dispositions that will help you dispose of your estate at the time of your death. I'll talk about a couple of other things that are also non-probate transfers in just a moment. If you have only one child, then the statutory scheme states that 1/2 of the intestate estate of the separate property goes to surviving spouse and 1/2 goes to the sole surviving child. If you have more than one child, then it would be 1/3 to the surviving spouse. So this is all laid out in Probate Code section 6401. And there's a scheme for it. There's a black letter statutory precise order of how things will be distributed if you died completely without a will. So in that sense, everybody's kind of covered, I suppose you could say, but it is, I think, well accepted and better to have an estate plan executed during the course of your life so that you could express the wishes that you want, and you don't leave the law, the black letter law, to dictate where those things go by the statutory scheme. Some things that are worthy of consideration is questions that people have. Does a will avoid probate? We already discussed that. A will not avoid probate. The only way you could avoid probate is if you do what we call a trust that we touched on earlier, or you can also use other vehicles to dispose of your estate by way of what's called non-probate transfers. And there's a specific probate code section that speaks to those. For example, if you hold your house, your residence, in joint tenancy with right of survivorship with your spouse, that doesn't have to go through probate. The joint tenant surviving spouse merely needs to file an affidavit. There's some steps involved. It files an affidavit of death of joint tenant, and with proper recordation of the proper documents, the title will be securely vested in the surviving spouse. It doesn't require opening up a probate estate with the probate court. If you have bank accounts, if you have bank accounts or investment accounts in your name, and you have a beneficiary designation on those accounts, you have $1 million or $10 million or whatever amount of money you have in an IRA or an investment account, a beneficiary designation to a spouse and children in certain percentages, to a spouse, and then if the spouse dies, there's a contingency that it will go to other individuals. That would be, if effected properly, would be a non-probate transfer that would also avoid having to go to probate court. If you have a bank account similar to titling a house, you have a bank account that's a joint bank account with right of survivorship. If your spouse presents the death certificate to the bank will conform the bank account to the name of the surviving spouse, and they can do what they want with the funds. Generally speaking, therein, there can be opportunities for dispute over that, but depending on who put the money into the account, but that's the general rule of how it passes, is by right of survivorship. You may also designate on a bank account. You may have heard of POD or TOD. POD generally applies to bank accounts, pay on death. Don't even need a lawyer for that. You go to the bank and you designate on your bank account that you wish a particular person or any number of persons to have your assets in that account on your death. That person is able to present the bank account, that person is able to present the death certificate, and they will get the funds in that account because it's a designation to the bank. I want this asset held this way, and on my death, I want you to do this with it. Pay on death to this individual or this number of individuals, 50% or a third, and a third to my 3 children. And that will typically be honored absent any challenges. And that's an effective way to dispose of an asset and also avoids probate. So while a will by itself will not avoid probate, if a will is done in conjunction with the appropriate number of non-probate transfers by beneficiary designation, you can avoid probate because there would be no assets in the probate estate to go through probate. If your estate is more complicated and doesn't have to have that many assets to really justify the consideration of employing a trust, you would go ahead and want to speak with your lawyer about establishing a trust. Other factors that folks consider when they're making a will or making a trust, for that matter. May I change my will? Of course you can. You can change your will anytime that you like, as long as you do the right things for a formal will by having it witnessed again. If you wish to make a codicil to your will, a codicil is a document that might best be described as a form of an amendment or a modification to the will. And it's a formal document that also needs to be witnessed, and it might change a provision or two of a will to update your will. Or you can revoke a will by a subsequent will in its entirety and rewrite the terms to how you see fit at that point in your life. So during your life, any testamentary instrument can be changed as long as you have sole control of those assets. They're your assets, and you want to change your expression as to what you want to do. You may do so at any point during your life. Obviously, you can't do it after you're no longer with us. That's when the will or the trust would become irrevocable. Best not to make changes by interlineations. We had the example of the gentleman who did a holographic codicil, but best not to make changes by interlineations or crossing things out or doing any of those things. Those could be very problematic. It could put an otherwise valid testamentary instrument into dispute. It's best to fully meet the requisites of a complete change by meeting the statutory requisites of a complete will, or if you're doing a trust, do a proper amendment to the trust that is complete in and of itself and signed. Well, that's about all the time we have for today. We didn't cover everything. It's an exhaustive area, and we will be taking this up in the next subsequent podcast that we have. And I thank you for spending time to have this conversation, and have a great day, and have a great happy St. Patrick's Day 2023.
You've been tuning in to Your Inheritance, Your Rights, Your Obligations, Your Responsibilities with your host, Peter Bochnewich. If you're being sued over an estate, or if you feel you're not getting your share, Peter's firm can help you. You can find this show at www.betrustlaw.com and on YouTube, Facebook, Apple Podcasts, Spotify, Google Podcasts, and more. Thank you for your positive feedback, comments, questions, and for sharing the show with others.